Good morning and good evening, everybody, and welcome to the USIBC Legal Digital Roundup with Khaitan and Company. I know this is actually one of our favorite webinars because it's such in-depth and high-quality analysis of what's going on in the policy landscape in India. So I want to thank our members for joining. As always, I'd also just like to thank a few of our leadership here at USIBC. I see Jared Doherty from Warner Brothers Discovery, one of our co-chairs. I really want to thank you, Jared, for coming. Really appreciate it. And if any of our other leaders are on the line and I'm not acknowledging you, my apologies. Here and now, we're going to talk about space policy. There's been some updates on ease of doing business. There's also been a lot of activity around cybersecurity, IPR, and financial KYCs. And that's why we have the experts from Khaitan and Company who are going to give us a presentation on each of those. It's nightly news style. And the way that works is that we'll hand it over to Tanu, who will introduce each of the speakers and the experts. We will go through some recorded, some slides, and then we will share those slides with folks afterwards as well. Anytime during the conversation, please feel free to raise your hand or populate a question in the chat. We set aside some time in the background at the end of the webinar for people to ask questions. And of course, if you want to be connected with any of the experts here, don't hesitate to reach out to me. With that, I'm really excited to have Tanu Banerjee back on the screen here. She's one of my favorite moderators. The slides you're about to see, they always do really great, informative slides. Tanu, let me just thank you and your team for just your professionalism. It just shows that you put a lot of time and effort into this. It's super appreciated by me, and I know the broader membership as well. So with that, I'm going to go off screen, off mic, and hand it over to you.
Thank you, Jay, and thank you very much to USIBC. Also, we enjoy these sessions equally at our end. A very warm welcome to all of our audience today. Thank you for joining us. A quick background of those of you who've joined us for the first time in our digital roundup. We typically run this session in a newscast format, largely because we cover several legal updates which are relevant to the digital ecosystem in India. The Khaitan & Co team present here today will be your respondents. All of them are specialists in their respective practices, and so they'll present to you major developments in their field of expertise. I'll quickly also introduce our speakers today, starting from the top left. We have Supratim Chakrabarti from our Kolkata office. Supratim leads our data privacy practice. He also does a lot of work in the technology space with a lot of technology companies. We then have Shobhit Chandra from our New Delhi office. Shobhit is part of the telecom practice. Shwetang Tripathi, who is from our Mumbai office. He's part of the IP, intellectual property practice. And then there's Pritish from our Bangalore office. Pritish does a lot of work in the fintech and the financial services space. And finally, there's me. I am a technology, media, and entertainment lawyer based in Bombay. But for this session, I'll be the moderator. A quick look at the agenda today. Jay already, of course, briefly touched upon it. We'll first have Shobhit talk about the Indian space policy and some recommendations from the Telecom Authority of India on ease of doing business. Supratim will talk to us about the CERT directions. These were enforced last year. The agenda today is just to talk about it, talk about some key takeaways for the businesses a year after. Shwetank will walk us through a recent judgment by the Indian Performing Rights Society in the music space. And then finally, we'll have Pritish talk about some changes in the KYC norms in the financial services space. With that, I will hand over to Shobhit to start off our first segment on the space policy. Over to you, Shobhit.
Thank you so much, Nanu. First of all, it's great to be here. A very good morning to all of you. As Tanu mentioned earlier, I'll be covering two topics in the course of this session. The first one deals with the recently announced Indian space policy. To start things off, this policy has taken a few years in the making. The government has been manifesting its intention to augment the space sector and tap the potential that it really, has in terms of firstly trying to expand private participation in the sector, and also trying to streamline various other activities that can be leveraged as well as launched in India to position India at a much stronger position when it comes to space activity overall. Um, to start things off, if we speak about the applicability of the policy, that's essentially covering any space activity which is defined firstly in a very wide manner. It seeks to apply to the territory of India, including its exclusive economic zone. Interestingly, as I mentioned earlier, it applies to both government as well as non-governmental entities, which are referred to as NGEs in the policy. It designates the Department of Space, or the DOS, as the responsible agency for implementation of the policy. So, aspects relating to its administration, dispute resolution, a lot of clarifications, and so on and so forth. So that is something that would be taken up by the DOS. If we talk about the vision and strategies that the policy envisages, there are a lot of factors here and a lot of emphasis that has been drawn on enhancing the space capabilities and enlarging and promoting the commercial presence in the sector. So, as I said earlier, there's a lot of emphasis on tapping the potential that exists here, driving technological advancements, and also positioning India in a place where it can be a global leader in the sector, which will be in turn instrumental in fostering international relations. It also talks about creating a conducive environment overall for implementing space applications, which can be used for myriad purposes, for research development, and for otherwise nurturing scientific temper. As has been a prime focus of the policy, which is to facilitate and incentivize NGEs to create a level playing field, which has so far been the exclusive domain of the government, to enhance their participation in the sector and also leverage things like, where they can be used for providing space-based communication, for operating satellites, for collecting remote sensing data, to be able to process that data and use it for various purposes towards environment protection, preservation, and so on and so forth. So there's a lot of emphasis to enlarge the scope of private participation in the sector. Also infuse a lot of research and development, and a lot of that will be spearheaded by the Indian Space Research Organization that will take place. And again, the emphasis here is also to provide goods and services using space technology, furthering national interest as well as positioning India at a much higher position. Now, the policy, because it is, after all, a policy document, this will lead to further amendments or further enactments of different laws and regulations that will help actualize or implement the objectives of this policy. It also talks about creating a stable and predictable regulatory framework. Now, this is something that has been a bone of contention for a significant amount of time now, and this is what has been a focus of the government here, to try to create a stable and predictable regulatory framework, which has so far been a huge deterrent for private entities, particularly ones located outside of India trying to come in. So if that were to happen, then that definitely would add a lot of strength to this entire framework. I will also try to juxtapose this and merge this with the next topic that I'll be covering, and we can perhaps touch upon that in some more detail there. But the idea there is to sort of enhance the role of India in the entire space sector as it goes. So then, in similar vein, moving on to the next topic, which is the Trai Recommendations, which were recently released in a focus towards ease of doing business in the telecom as well as the broadcasting sector. So first and foremost, because these are recommendations, by their very definition, are recommendatory in nature. They're not really steps that have been implemented already. These will come into place subsequently. It could be by way of amendments, again, enactment of new laws, regulations, guidelines, and so on and so forth. It'll have to be seen how they really play out in the longer run. If we are to talk about these recommendations, they are quite broad in their objectives, of course, and they've also the TRAI has, of course, tried to cover a lot of aspects here. What I've tried to do in the interest of covering this, in this short window is trying to cover some main themes and focus areas that emerge from the recommendations. Many of them may not be set out in this manner in the recommendations. This is more of the takeaways that we've gathered from it. And tried to present it before all of you. So first and foremost, there's a lot of focus on creating a single window clearance system, which would cut across ministries and departments. Again, the prime aim being here is to facilitate setting up of businesses to obtain approvals and processes. There's also a recommendation that each ministry and department should develop and appoint its own ease of doing business committee. So that is something that is critical from an ease of doing perspective. Also, in terms of enhancing foreign direct investment, giving some sort of regulatory certainty as well as convenience to parties. In following with that, so there's also a lot of impetus on simplifying processes for approvals, permissions, clearances. So this essentially is in the sense of on topics relating to frequency assignment, when it comes to surrender of licenses as well, and trying to improve the processes when it comes to doing all of these things. There is also focus on streamlining compliance burdens with ongoing compliances as well as reporting requirements. So, for example, in the telecom sector, there's been a recommendation that the lawful interception and monitoring equipment can be demonstrated at a central location for a service where the network is at a central location. Also, the frequency of reporting has sought to be reduced for some of the internet service providers, because that has been a bit of it's a time-consuming process, takes away a lot of bandwidth from them. There's also an attempt made to bring the FDI reporting compliance within an online mechanism which already exists with the DOT. So the Trai is suggesting that that online portal can be expanded and leveraged for other activities as well. The other focus area is to avoid regulatory duplicity with involvement of various different wings and departments of the government. So, for example, when it comes to testing and certification of equipment, there are several regimes that coexist. So there's one by the Ministry of Electronics and IT under the compulsory registration order. There's one by the Department of Telecom through its Telecommunication Engineering Center, which is relating to the mandatory testing and certification of telecom equipment. So all of these, and of course the Bureau of Indian Standards regime. So all of these are sought to be harmonized and see how best they can be leveraged. There's also suggestions to augment deployment and establishment of infrastructure. So how can approvals and processes be improved? How can it be made easier to bring in investment and things like that? There's special focus that has been laid on cable landing stations and repair of submarine cables, because that is something that has garnered a lot of eyeballs in the recent past, has been hotly debated also because there's been concerns with the timelines for establishment of CLS and repair of cables. So with that, I'd like to hand it over back to Tanu and transition on to other topics. Thank you so much.
Thanks, Shobit. But before I move on to our next topic, maybe, just quick questions on the space policy and the Trai recommendations. One, do you think, once space-based communication, let's say, become, more frequently used, or, sort of become part of the framework, is it in any way going to impact the telecom industry in general?
Absolutely. I think even in the present context, although the license conditions are quite rigid in this regard, because what they speak of is use of certain types of satellites and by licensees for providing a service. But the use of satellites even today is quite omnipresent, especially in terms of bringing connectivity to certain remote areas. I think that can be taken a step further when we'll have probably entities who can provide satellite-based internet connectivity, for example, trying to expand their area of coverage and perhaps also bring cost efficiencies into the sector.
And on the Trai recommendations, I know you did say that, they're not really statutory at the moment and more in the form of recommendations, of course. But India and globally, I think there's a lot of work going on around setting up data centers specifically, right?
Yeah.
Do these recommendations then therefore have some sort of impact on data centers and, maybe just generally technology companies overall?
Right. So I think most technology companies have consistently struggled with the fact that, the regulatory environment in India and the entire framework is quite different to how it exists in many other countries. So while other countries may allow them to do certain things in a particular way, that has always been a bone of contention between tech companies and the DoT here. What the recommendations aim at doing is, in addition to simplifying processes and providing a single platform for clearance, also lay a lot of emphasis on augmentation of infrastructure and particularly submarine cables. So when it comes to data centers, for example, you could have submarine cables landing from cross-border locations, allowing you to establish data centers here and bringing that connectivity to your data centers and providing and helping in creating India or positioning it as a regional hub. I think that will go a long way if it really actualizes in the intended manner.
Got it. Great. We might have to do a roundup again on this a couple of months later.
Yeah, absolutely. It's extremely
all right.
developing.
Thank you
so
Shobit.
much. Yes.
We'll have Supratim next. Supratim, over to you.
Yeah, thank you so much. The topic that I'll cover is actually a pretty hot one and much talked about right now, which is the SCERT in Computer Emergency Response Team of India, the direction that was issued 1 year back on 28th of April 2022, the journey thus far and what we have observed and some takeaways. Okay, so to start with, SCERT in is actually a national agency for incident response. And earlier, it used to be a relatively quiet, dormant entity. There were certain provisions in the 2013 rules of SCERT in, which talked about reporting a small set of cybersecurity incident as early as possible to leave scope for action. So no hard timeline was provided. But during COVID times, we observed that there was a lot of ransomware attack, etc., because of which CERT was kind of under scrutiny. On 20th of January 2021, CERT came out with an advisory where they said that if there is any data breach or data leak, both of these are undefined terms, by the way, then you need to immediately report to the CERT. And you will also have to report to the affected users or customers. Now, this is the first time that data subject reporting came into the forefront in the form of an advisory. And we thought probably this is an advisory only, and it may not be made a hard obligation. Interestingly, in some instances that we have seen, we have observed that the SCERT has actually gone ahead and pushed this advisory to affected organizations and said, have you complied with it? Okay, let me give you an example. In one of the instances, our client was a merchant, and the breach actually had occurred at the payment systems service provider level. And the notice which was received by the merchant stated question number one, that did you report this instance to CERT in? Question number two, did you report to the affected users or customers of your service? And right below that, they had pasted the advisory link. So in effect, indicating that you are required to follow it. In a bad day, no player would really like to go ahead and say that this may not be what the Information Technology Act, the mother legislation, seeks to set out. So anyway, so after that, in 2022, on 28th of April, this famous CERT in direction was issued, and one of the requirement was 6 hours breach reporting. The cybersecurity incident had to be reported within 6 hours of noticing the incident or being brought to notice about such incident. Uh, there were some meetings with the ministry, and I think the messaging that happened is that we are trying to see that overall posture of cybersecurity is bettered in the country, because of which we are having this. And there were some other requirements like synchronization of ICT system clocks, localization of system logs for 180 days, etc. Now, interestingly, on 22nd of April, some of the players received show cause notices dated 22nd April. Most of it was received earlier this month. That you had been late in reporting a cyber incident. Please show cause why you were late. And there were provisions which indicated imprisonment, etc., was also mentioned in the show cause notice. So of course, the industry woke up, and we had to assist several players to prepare responses. Um, Now coming to the key takeaways from this entire 1 year journey are as follows. Number one, if there is a cyber incident, a cybersecurity incident which you have to report, and there is a delay, if you're able to firstly understand that it is reportable, please go ahead and report it with whatever information is available with you, and then follow it up with further information. In case there is a delay which has happened, it would be advisable to put in a sentence or so as a reason for the delay. The form of giving that particular information is not now mandatory that it has to be in the form that was there of certain, and it has to be signed, etc. It can be in any mode of communication. In one of the instances where there was a ransomware attack and the entire system was down, even fax was accepted, and that worked okay. Be prepared for follow-on questions, quite elaborate follow-on questions. And if it is a ransomware attack, also be prepared that one of the points which would be put through to you is that, have you reported this complaint to the cyber cell or the law enforcement authority? You should please share this complaint details also with us. So this is a slight problem. The reason is that sometimes companies are okay to go ahead and report to CERT because there'll be confidentiality, which is kind of assured. But when you go to a local police station, etc., that becomes a bit of a challenge and not so certain an information divergence. I'll pause there. Back to you, Tanu.
Great. Thanks, Upatim. I remember when the initial notification had come out last year, there was, like quite a lot of panic amongst everybody. And then that sort of led to, I think, a bunch of FAQs from CRT and so on. And we, of course, seen a year of that. So that's very helpful. But I was, generally curious in terms of, how are companies or businesses really reacting to these, show cause notices? And, I noted that you said you've, helped them prepare responses and so on. But in general, what's the reaction around this?
A very pretty interesting and good question, Tanu. Actually, if you see these people who are right now getting show cause notices are probably the good boys. Maybe they were late by a day or two or few days, but they actually went ahead and reported, and now they have got these show cause notices. As a ripple effect, what we are observing in the market is there are players who are coming and asking for legal advice to justify why a particular incident is not reportable because they are already late. So I think it's not the correct approach. And Jay and I have spoken. Probably some advocacy needs to be done on this front, and we are trying to make India a better cyberspace. But I think people who've gone ahead and reported should not be wrapped on the knuckle this way.
Thanks, Supratim. We'll move on to Shwetank with that. Shwetank is going to talk about music, so I think that'll be fun to hear him.
Thanks, Tanu.
Yeah.
Just waiting for my slide. Next one. Yes, that's the one. Okay, so I'm going to brief you all on a recent Bombay High Court judgment which was passed few days back. So I'll start my segment with a question that if you want to use a sound recording, that is a song, anywhere commercially, as in a showroom or a office or a restaurant or an event, anywhere, what do you need to do? So as we understand that we are going to seek a license for that. But the real question is that who do you seek license from? Because under the Indian copyright law, and I think in other various other jurisdictions as well, so separate copyright exists in the music, which forms part of a song, in the lyrics, that again is a part of the song, and the sound recording, that is the song itself. So there are three separate rights. So under Indian law, in order to ease this process of obtaining license, there is a provision for copyright society. These are registered statutory bodies in India who represent these copyright owners and collect royalties and distribute it to them. So there was a significant amendment in the year 2012. So it is important to know what was there the legal position before 2012, which led to this 2012 amendment. So pre-2012, and there has been a Supreme Court judgment in 1997 which fortified this position, is that the author of a music and the lyrics, once they create their work and they sell their rights to the owner of the sound recording, which will be the commonly known as the label or the producer. So all rights of those authors it gets extinguished then and there. Thereafter, and as we know, at least in India, the copyright in a song lies for 60 years from the date of release. So the author of the music and lyrics will assign their right to the producer who will exploit. And now we know that how many modes of exploitation of a song is there, as in the producer makes a lot of money. And what these creative people, the authors of music and lyrics, got was a paltry sum, and they were not at a good bargaining position. So they were paid something, and all their rights got extinguished. So there was huge uproar all the time, but it reached the Indian Parliament in 2012, and industry representatives also made their speeches. So the crux of the matter was that even after the author of the music and lyrics get their right assigned to the producer of the sound recording, they should still have a share in the royalty that is earned by the exploitation of the song, because essentially the heart and soul of a song is the music and the lyrics. So due to this, this affected an amendment in the Copyright Act. Now the amendment was not as clear as it should be. The motive behind the amendment was to carve out or to protect or to provide special rights to the authors of the music and lyrics. But the amendment came in the form of provisos and additional subsections. and there were no amendments to the substantive provisions. So the amendment came in 2012 and we are sitting in 2013. Interestingly, this issue never got determined. There have been proceedings initiated for or against these authors of the music and lyrics, but there was no authoritative finding. And in fact, this same issue, the effect of the 2012 amendment, is being heard in quite detail before the division bench of the Delhi High Court. Because the amendment were not clear. However, we must note that in practice, IPRS, which represents the interests of the authors of music and lyrics, have been collecting royalties and there have been agreements. So industry-wise, they have been getting money, but the entitlement was not crystal clear. So while this issue is pending before the division bench, that is 2 judges of the Delhi High Court, the Bombay High Court, the single judge, one judge took up this matter, examined the effect of the 2012 amendment. Since the amendments were not clearly laid down, it also went back to the legislative history. That is the debates that happened in the parliament and the whole legislative history. And the court determined that yes, the effect of the 2012 amendment is that the authors of music and lyrics has a separate right to collect royalty whenever a sound recording is used. The logic the court adopts is that once a sound recording or a song is played, so in a way, the underlying music and lyrics, which forms part of that song, also gets utilized. Each and every time a song is placed, these works are also utilized, and therefore PPL, which represents the interests of the sound recording owners, that is the producers, should not only get the whole cake, it should share it with the authors of the music and lyrics, which is represented by the IPRS. Now, this is an interim order, and we don't know whether so far it has not gone on in appeal. But and considering the same issue is pending before the 2 judges of Delhi High Court, it will be interesting, and we'll have to wait and watch this final outcome of these proceedings. But as of today, this is the legal position that if you want to use a sound recording anywhere where you are going to make money out of it, you do not have to take only a license from the owner of the sound recording, that is the producer. You also have to take a separate license from the authors of the music and lyrics, and they are represented by the Copyright Society, that is IPRS. So we have to take 2 licenses, one from the PPL and one from the IPRS. So this is the business implication of this judgment.
Great, thanks, Shwetank. It seems more complicated. Music seems much simpler to listen to, but much complicated, in legally. But then, my quick question here is: are you therefore saying that if this interim order was to, finally see light, does it then mean that to license a song you'll have to actually pay 2 separate license fees to 2 separate entities potentially?
Yes. So one clarification is that although this issue has not been debated in the judgment, is that 2 separate licenses would have to be taken, but it is not as if I have to pay double because the producer and the authors of the music and lyrics are entitled to the equal share of the royalty. So the amount should remain the same. It is only that rather than going to one shop, we have to go to the 2 shops now.
And presumably the 2 shops are aligned amongst themselves.
So that will take some time because PPL has been the sole winner all these years. So I think there will be some issues and it will probably come up in one of the legal proceedings. But this is what the law says, that the royalty share is to be equally shared by both these people.
Understood. Great. Thanks, Shwetank. We'll move on to our final speaker for today, Pritish. Over to you, Pritish.
You're on mute, Pratish.
You're on mute.
I'm so sorry about that. So today thank you so much, Tanu. So today I'm discussing the recent amendment to the RBI KYC Master Directions, which was notified in April last month, on April 28th. This current amendment has been widely discussed and debated across various financial sector players, wherein a lot of things are being left for interpretations and clarity. So RBI basically determined the purpose for this amendment was primarily for the alignment with the Mother Act of KYC, which is the Prevention of Money Laundering Act, which applies to all the financial sector regulators. Then to look at the updated sanction list, which the UN Security Council had published. Then the Financial Action Task Force recommendations, which were given for each member countries to comply with. And also RBI looked at refining its existing customer onboarding techniques and platforms. So currently, in terms of the key amendments, RBI introduced new definitions in its KYC amendment, wherein it defined as to what is a group. So essentially, the Financial Action Task Force requires each members in a particular, each entity in a particular group to comply with the PMLA norms wherever it's applicable. Then there is a revised threshold for determination of beneficial ownership from 25% to 10%. And there is an enhanced due diligence measure for non-individual customers, essentially for partnership firms and companies. Now, in terms of the key amendment over here was the enhanced due diligence for non-face-to-face customers. So essentially, non-face-to-face customers are those set of customers who are onboarded digitally without physically meeting the customers, or when the customer does not go through a video KYC form of a verification authentication. Now, over here, RBI has given many strict norms as to how to comply with this enhanced due diligence measures, wherein RBI has said that there are only two forms of KYC process now, which will be considered as full KYC, which will now be the video KYC and the physical meeting of the person. This actually leads to a lot of discussions as to what happens to the fate of the other KYC measures, which the majority of the financial ecosystem we're looking at, like DigiLocker, Central KYC Registry, and the offline Aadhaar XML verification. Now, over here, RBI is saying that anyone who undergoes the digital verification through Central KYC or offline XML KYC or verification through DigiLocker will have to also undergo video KYC or a physical in-person check with its customers. Also, all these customers who are onboarded digitally without physically meeting or through video KYC have to undergo will be categorized as high-risk customers. This has led to a lot of debates as to whether Central KYC, which was earlier a ledger, which had this KYC records of all the of all the customers prevailing from all the financial sector regulators, was present over there, and people and the banks and NBFCs are very happy to use data from the registry and for onboarding this customer, which was also cost efficient, as well as it took less time to enable customer onboarding. So this is an issue right now which the industry is facing, as well as there's another issue that the customer's registered mobile number, which is registered with a bank, has to be the same mobile number which has to be the mobile number of the mobile number registered with Aadhaar. So essentially, the mobile number which is registered with the Aadhaar of the customer, as well as the customer's registered mobile number of the bank, has to be the same, but wherein a lot of banks and NBFCs are not privy to such data. So this has led to a lot of rejig and understanding as to how to go about these concerns. On the central KYC registry part, as we already mentioned, that there's a lot of debate as to how to go about whether it's a full KYC or not. There has to be a mandatory uploading of the central KYC records within 10 days of account opening. We can move to the next slide. Then in terms of other key amendments, the explicit consent of the customer has to be obtained for any information which is not provided in the KYC policy of the customer. The updated UNSC sanction list, which has to be complied with, and a group-wise KYC policy, which I earlier mentioned about, has to be implemented. And any updated OVD, officially valid documents or verification documents of a customer, let's say if there's a change of address, has to be submitted within 30 days of such change. So these were the key changes which RBI has introduced in this KYC master directions, which has actually led to the financial sector ecosystem to go back to the drawing board and rejig the entire customer onboarding process and platforms. So over to you, Tanu.
Thanks, Pritish. I just noticed on your slide, one of the things that you said just now is One of the implications being that the registered mobile number of a customer has to be the same as the number registered with the Aadhaar authority, right?
Yeah.
I'm just wondering, it's possible for a user or a customer to register, different numbers, right? With both of these, with let's say a financial institution and with the Aadhaar authority. So in terms of ensuring that the number is same, how does a financial institution then ensure that the number is the same? It's
So
really
typically,
in the
yeah.
hands of the customers practically, right?
So it typically depends on what kind of process the financial institution is looking at. If they are just doing a verification of Aadhaar through a normal check, then this is something which is not possible. They have to undergo any form of an authentication for ensuring that the customer's mobile number is available to them. And a lot of these current industry, as industry market practice, a lot of these financial sector entities were looking at an offline-based Aadhaar verification to onboard customers, which does not provide mobile number registered with Aadhaar. So that's the issue which the industry is currently being facing right now.
Understood. Good, great. I think with that, we're at the end of our slides for today. Back to you, Jay.
Great. I'm going to start with Pritish and ask a question. And if all of the speakers want to come on screen, that'll be great. So if you look at our topics today, we started with space, clearly a positive, right? Possible opening liberalization, devil in the details. There's a lot of implementation to do, right? Then we moved on to try, ease of doing business, definitely positive recommendations. Granted, need to be implemented, but the direction and implication is interesting, right? Positive. And then we talk about SCERT, where maybe it's going to become harder to actually comply with rules. And we talked about IPR. I'm not sure if that's positive, negative. It seems sort of egalitarian and maybe a split decision there, depending on which side of your intellectual property rights you own. And now we come into the KYC, which to me sounded like adding a fair bit of complexity. Is that accurate to say? How do you actually interpret these rules? Are these positive in the sense that they align and streamline, or do they add complexity, make it more difficult, and will be confusing to customers and institutions alike? Just like, what's your read on it?
Yeah, so in terms of the current amendment, the entire way the Indian fintech ecosystem is moving, wherein we are moving towards a presenceless and paperless onboarding of customers. This has got a serious hit because now there has to be a multiplicity of KYC. Anyone who's doing any form of KYC has to also either physically meet the customer or do a video KYC of the customer, which essentially leads to a lot of customer onboarding flow is not that smooth anymore, as well as it's the time taking process is also very high, and also the costing. The costing for a video KYC ranges is 10 times higher than all the other measures which the current ecosystem was using. So that's where there is a problem within the financial sector ecosystem in implementing these measures.
Wonderful. Thank you. We have a question from the audience. I'm going to go over to you, Rakesh. Please either come on screen or audio and ask your question, sir.
Hey, hi Jay, and hello everyone. My question is to Pratish, and which goes to the recent amendments done by the RBI on the master directions of KYC. So I'll begin. So I represent Stripe, which is a global payment aggregator, and with a presence in India as well. Now, when I look at the PAPG guidelines and the subsequent clarification provided by the RBI on 31st of March 2021, and it says that the clause number 4.2 says that there would not be a requirement to carry out the entire process of KYC in accordance with the KYC guidelines of Department of Regulation in cases where the merchant already has a bank account which is being used for transaction settlement purposes. So which essentially means is that for payment aggregators like us, we are already doing a settlement in a KYC'd account by the bank. So we are not taking a separate KYC. We are just doing a bank account verification with a penny drop.
Penny drop, yeah.
Right. Now, when I look at the recent amendments in the master directions of KYC, and I'm specifically going to clause 56, subpart B, which says that the regulated entity shall capture customers' KYC records and upload onto CKYCR within 10 days of commencement of an account-based relationship with the customer. Now, I feel a sort of disconnect between both of these clauses. Now, my question is, how do we sort of interpret like whether we should go ahead with what RBI has said in the PAPG guidelines, or we should go ahead with what has been said in the master directions of the KYC. The second is the KYC, the recent amendment in the KYC talks about account-based relationship with the customer. Now, in case of the payment aggregators,
there's no account-based.
There is the user which we are onboarding is actually a merchant. It is not the end consumer or a customer. Right? So shall we treat that relationship also an account-based relationship? So what are your thoughts and views on that?
Yeah, that's a great question, Rakesh. So I'll just go one by one. So on your CKYC bit query, wherein we have to upload the documents, the updated documents within 10 days. So this was actually always present within the SCERT guidelines. So what RBI has done over here is they have just tried to imbibe that current SCERT guidelines within the RBI KYC master directions, and they have asked them to basically upload those data within 10 days. Now, coming to your point, what is the role of a PAPG over here? As you rightly mentioned, that the RBI KYC master directions does not apply to a PAPG primarily from a limited standpoint only, primarily because there's no account-based relationship with the end customer. Because the onboarding which we are doing essentially is of the merchant, where we assign them a merchant category code and we onboard them. So over here, the only thing over here we have to look at is that the merchant over here, wherever we have the sub-merchant concept or that kind of concept we are taking in, we should ensure that those sub-merchants, if they are individual entities primarily, have been their documents updated within 10 days. Essentially, the ambit of the RBI KYC master direction primarily does not go on to the PAPGs, because a lot of PAPGs have also gone to the RBI to check what is their role under the current RBI KYC master directions. And that's what they have been told, that your role is very limited. Just ensure that you have done a basic KYC of this person to ascertain that to a certain 3 checks, whether the merchant is actually the real person. Second is to ensure that the person, the address which they are provided is actually the current address. So you can use basically a geotagging, or you can basically visit that that merchant's address. And the third aspect is the income aspect, which RBI said that could be relaxed, because herein we are not looking at the income aspect over here. So on the CKYC bit, within 10 days, right now doesn't, in our view, doesn't apply to the entities as such, which are merchants, because RBI has been very clear in its, and DPSS has also given that opinion that the KYC master direction has to be very limited in the scope. And to your second question was in relation to the enhanced DD1. Hello. Yeah. You're on mute, Rakesh.
Okay, so my question was whether the relationship which we are having with the merchant should be sort of considered as an account-based relationship.
Yeah. So it's not an account-based relationship, which DPSS and other market players have also gone and clarified. The KYC master directions are applicable in a limited way because it's a non-account-based relationship, as you rightly pointed out, because the end customers here are not our customers. And essentially, PAs are doing their own set of onboarding as per the PAPG guidelines, and then thereupon they assign the merchant category codes.
There is an exemption available to the PAPGs.
Yeah, in a limited manner, and those enhanced DD measures will not apply.
Okay, thank you. This is helpful.
Yeah.
Jay, you are on mute.
Jay, you're on mute.
Now it's my turn to be on mute. Thank you. If you have any questions, raise your hands or put them into the chat. But I have a question for Shwetank, if you want to come, you're on the screen, but it has to do with IPR. I saw in your presentation that the last round of IPR updates were in 2012. A lot has happened I know that there is some cinematography bill sitting at the Standing Committee of IT for at least 3 or 4 years. And there's also been some news about maybe updating India's IPR or copyright. What can you just share with us about any general IPR reforms that may come down the pipeline and key issues that may or may not be addressed?
IPR is currently very burning, and a lot of changes are happening, not only from the regulatory or the government side. The courts have taken this responsibility and they have been passing exceptional orders and somewhat path-breaking orders due to the changing dynamics of the market or the way we lead our lives. For example, there have been, for example, a software is not a patentable product in India. But the courts have issued directions to government to reconsider whether that can be patentable in some specific circumstances, because it is patentable product in US and various other jurisdictions. So one is that, and the other one is that considering the lockdown and everything going online, a lot of infringements are happening. For example, a new content is generated, so immediately the copies are being circulated, the fake copies. So the courts have not only granted injunction, the courts have granted dynamic injunction, that you file a case, and if somebody, because it is so much easier to just mirror and change a word here and there and create another link, then I'm not supposed to go to the court again. The court will grant a dynamic injunction that I'll just go to the administrative side of the court and say that, see, I've got an injunction with respect to this, and now there are 10 more websites that have come up with a few words here and there. So the court will give me automatic injunction that I do not have to file a case afresh. So these are some of the cases that the courts are actively taking up, and I think there is a lot to come.
I think Jay,
Great,
just to
thank
add
you.
to what, quickly to add to what Shwetank was saying, and to answer your question, I think yes, the Copyright Act is due to be amended, and we've seen some versions of the drafts in the past as well. I think one of the things overall that people in India are looking forward to is to streamline, distribution of royalty, which is right now not really codified. The manner around that is not codified under our existing Copyright Act. That's one. And the other is that the copyright legislation, it is a 1957 legislation yet, so it still needs to catch up to the digital times, so to say. Right. So overall, two of these aspects, I think, is what everyone's looking forward to streamline.
Great, thank you. And I've heard from a lot of our members about the need for trade secrets as well to be protected in India as a IPR. If anyone has the ear of the government, something that I think could really help enhance the regime for intellectual property. We have a question from Reshu. Over to you.
Hey everyone, thank you for that briefing. I had two questions. One to Supratim. You mentioned some companies were issued show cause notices. Any, sort of top reasons why, on what basis these were issued, and to whom? And my second question was around the SATCOM auctioning, and it was mentioned that a lot of the industry folks are sort of against it. Want to understand the reasons for that opposition as well. Thank you.
Right. Thanks, Vishwa. Maybe I'll take the first question and then I'll hand it over to Shobit. So we initially thought that probably the show cause notices were issued to only players who had incurred serious cyber incidents like ransomware attack, etc. But later on, we understood that it was actually even for a lesser degree of cyber incidents that they were issued. So we are not sure whether any particular benchmark was issued, it was kept in mind, but it is kind of across the board as far as the kind of cybersecurity incident is concerned. Over to you, Shobit.
I'm going to just, before Shobit answers, Super Team, the show cause notices are private communications, right? So as a community, we're not going to know how many were issued to whom or whatnot. So what we're hearing now is sort of, I want to say dribs and drabs. We're hearing about a handful of cases because we're just hearing about them. There may be others out there, there may not. Is that a fair assessment? So we don't really have a full understanding of what's going on in the back end.
That's right, Jay.
Has anyone reached out, or has your offices reached out to SCERT to sort of ascertain what's going on? Has something changed? Is there a new guideline or benchmark? And then, of course, the obvious question is perhaps that's something USIBC should do. It's a question, but.
Right. So I did reach out, but maybe we can take it, off the record
Offline.
separately. Yeah, offline.
Thank you, sir. Shobit, over to you on
So-
SATCOM.
Right. So I think the issue on SATCOM really emanates from the fact that I think globally, if we look at spectrum that is earmarked for satellite comm, is normally administratively assigned. But if the same were to be auctioned, in the same manner as access spectrum is otherwise in India, then that may lead to additional entry barriers for many of the entities who are looking to foray into this space. So I think that's mainly been the reason for the opposition so far, at least based on what we've seen and heard. It's also important to know that Trai is also sort of currently engaged in a consultation process in terms of how to leverage spectrum for space-based communication. So it'll have to be seen how that pans out in the near future and eventually what form and shape it takes. But yeah, the issue really seems to be how if the spectrum were to be auctioned and what kind of entry barriers and other challenges that would bring to stakeholders.
Thank you. Rashu, I'll add that at least the SATCOM operators internationally would also articulate beyond the economic impacts of it. The spectrum is non-exclusive. It's a fairly narrow beam, and so there is a lot of spectrum reuse. So then the question would be, how do you even auction it? Because it's geographically located, and that same spectrum could be used physically in an area nearby. If it's a mountain or jungle area, it could be used very closely nearby. If it's desert, it's a little bit farther. But then you would have to, in essence, not only auction the spectrum in terms of how much spectrum, but its overall use in a geographic sense. And so it become very complex. And so a head end or a VSAT operator might move or add in, and then therefore, how do you go back in and sort of change that? So historically, it's been done through a non-interference conversation that's handled at the ITU. And so now historically, you have, closing in on 50 years of norms of how the industry operates globally, with a very few experiences otherwise. And those few experiences are rather dated and fairly narrow and not generally applicable. And so now there's this proposition to do something very different in India that would not only disrupt the international mechanisms for doing this, it's a cost inhibitor for a service that is generally seen as augmentation and somewhat, in terms of competition or overlay with the terrestrial network. There are compelling reasons to continue with the allocation of spectrum on a non-exclusive, interference-based regime that is just used everywhere. Shobit, while you're on the screen, I have a follow-up question. There's some real, I guess, devils in the details here about FDI. I mean, in theory, India has, for many years in its SATCOM policy, had both an open skies policy as well as allowing FDI. However, in practice, neither were ever implemented. And now a new SpaceCom policy comes out that, in essence, sort of it revalidates some older policies that were never implemented, right? And now you have another organization perhaps driving forward some of those requirements. So what are you hearing specifically about FDI, when are there going to be, stated clarifications, perhaps even approvals of FDI on the one hand, and then the second hand, are we really going to see INSAT as the satellite operator allow open skies and people to contract directly without going through Israel? I mean, is this pie in the sky? Over to you.
So I think, as rightly said by you, there's a lot of familiarity with what we've seen in the past, and that is no doubt a very pertinent question. Of course, finer aspects relating to FDI may eventually be dealt with, in specific amendments or rules or policy changes in the FDI policy that may take place. But yes, I think at a large level, it's a lot left for what may happen as a next step rather than covering it explicitly within the part of the policy. So yeah, I think it has to be seen how this will take shape when a more cogent document pursuant to this policy comes out and how it's going to deal with this aspect.
Great, wonderful. Well, listen, last chance for questions or comments from our participants. All right, well, this is always one of my favorite webinars. We have a group of experts here that really presented true insight. I want to thank you all. Tanu, Jared, over to you. Have a question.
Nothing coming from me. I was fat fingering while I was trying to send some applause. But thank you guys. Really a very instructive session, and it really is must-see TV. So appreciate it. Yeah.
Thank you.
Well, thank you. We are happy to connect anyone here to our experts here. Let me thank Tanu for expertly moderating this group. I want to thank Shobit for just insights in SATCOM and ease of doing business. Super team, it's always a pleasure hearing, even when the news isn't always positive. We appreciate the straight and frank talk that you provide us. Shwetank, want to talk more IPR. I think it's an area that we could really do a lot more. So thank you for those insights. And, last but not least, Shobit, Pritish, really thank you all for everything. And we hope to have you back in a couple of months. We do this every 2 months or so. If any of our participants here have any topics they want to raise, let us know. Otherwise, we'll be sharing the slides. Let me thank our participants all over the world, from Singapore to the West Coast of the United States. Appreciate your time. Thank you. Good morning, good night, and good afternoon for you all. Take care.
Thank you.
Thank you all. Thank you.
Thank you.